Hey guys, Colin Murphy with The Straight Dope. Appreciate you turning in. We had a great conversation with Carl Olsen. Stay tuned for episode 1 and be sure to catch the end of that conversation in episode 2. Welcome to The Straight Dope, where you hear the real talk about Iowa Vice. Hey everybody, what's up? Welcome back to The Straight Dope. I've got a very special guest today, Carl Olsen. Carl, welcome to GRL, the 440, Ponderosa, West Des Moines, and the Straight Dope podcast.
Thank you, Colin.
I'll tell you that a couple of things. One, when we were sketching out this concept, I told everybody, I got to have Carl on very early. He's got an incredible story. And so the fact that you're here is kind of a fulfillment of that goal already. But I need to give a little bit of background about how we met, because it sets up the background for, I think, the story that people are going to hear. And 2012 maybe, so it's about...
Yeah, that's what I think.
Yeah, about 12 years ago, we were fortunate to get a ruling in the Iowa Supreme Court that raised at the time, a First Amendment religious freedom defense to a simple misdemeanor traffic ticket in Mitchell County. Old Order Grofdale Mennonite family, 13-year-old boy who was driving a steel-wheeled vehicle on newly paved roads. They gave him a $10 ticket for that, and we defended that ticket with the magistrate up to district court, made it up to the state Supreme Court, and we raised a difficult argument. It was difficult for me to put together and argue religious freedom for doing something, for being criminalizing something that other people were able to do. So school buses, ambulances, other vehicles could drive on these paved roads, but Grofdale Mennonite, Old Order Grofdale Mennonites in their steel wheel vehicles could not. And so the one person who understood that argument as well as anybody was you, and you reached out to me. Now, I didn't know the background at the time, and the background is the story that we're going to talk about today. But you've had a religious freedom defense to the use and consumption of marijuana for going on probably about 50 years. And this has been raised and litigated in a number of contexts. And it continues today. And I think that there's no one, certainly in this state, probably the country, that knows as much about religious use of controlled substances than you do. And so thank you again for being willing to come here and share your story. I want to talk a little bit about 20 tons of marijuana. You were charged, along with a number of other people, of importing, smuggling, and people that know me, they know I love a good smuggling story. Smuggling 20 tons of marijuana. You had a defense to that charge. What was your defense in 1983 in federal district court in Maine to importing 20 tons of cannabis?
Well, the church members had been arrested prior to that. I can't remember when the arrests started piling up, but that was in 82. There were already cases going on in Florida in 79 or 80, somewhere in there. So the church raised a defense based on the First Amendment to the Constitution. And I can't remember if there was an equal protection component or not. I had one because Iowa has a religious exemption for peyote, and so does the federal government. So between those two states, I had a tight equal protection argument. But I'm not sure if all the states that all the church members were involved in had peyote exemptions. So the First Amendment was a standalone defense, affirmative defense, kind of like medical necessity or whatever. Yeah, I did it, but I had a right to do it. It was for a good cause. So that's a no harm, no foul, like victimless crime. There was, in all of these busts, no weapons, no violence, no victims, Can you imagine with that amount of marijuana, if marijuana were dangerous, that there would be no victims to step forward and testify? And not only that, these are only the things we got caught for. Like, they knew we were trafficking lots of stuff we didn't get caught for.
And when you bring up church, I don't mean to interrupt you, and I should have mentioned that.
Yeah.
What we're talking about is the Ethiopian Zion Coptic Church, and you've been a member of that church since the early 70s. And
It's an offshoot of the Rastafarian movement in Jamaica. It started in the 1930s. This is a branch that set up under the name of Ethiopian Zion Coptic Church.
And as a member of the church, maybe briefly describe the role that cannabis plays as a sacrament, the use of cannabis on a daily basis.
Well, we were the first church to be incorporated by the Queen of England and the Parliament of Jamaica. So of all the Rastafarian churches, I think we were the first ones to incorporate in Jamaica and establish an identity and own large amounts of property and so forth. The religious use of marijuana is that it gives you a spiritual insight into yourself and kind of exposes yourself raw. As you move through life, you do a lot of pretending, especially if you're a marijuana user. You're pretending like, I'm not breaking the law, or I'm not going to tell you where I hide my stash. So you're pretending all the time. Cannabis has a way to where you really see yourself, because you tell enough lies, you start to even believe them and stuff. But when you're on cannabis, you have to be really honest with yourself. So doing this in a group setting has a religious component to it where it brings out the truth and people are honest with each other, and it kind of, it's more important to be honest than it is to hold some kind of imaginary pretending or whatever.
And so when you're a member of the church, this is down in Florida,
Mm-hmm.
and you are using marijuana on a daily basis,
Mm-hmm.
and consuming it sacramentally. It's part of the sincerely held religious belief that you have.
Yeah.
And when you are arrested, you mentioned these buses. There are buses in Florida. There are buses in Iowa
Mm-hmm.
that you're part of. There are buses in Maine. That's where the 20-ton amount comes
Yeah.
from. You are raising as a defense to those prosecutions that I have a First Amendment right to exercise my religious belief.
Right, and in every single one of those cases, mine and all the others, no violence, no victims, no weapons, just marijuana cash, property, and that's it. Happy people doing a happy thing, and all of a sudden, somebody comes and says they have to interfere with that. They have to make your life miserable.
And so now you've got the full force of the government of the state of Florida.
Mm-hmm.
So at the time, this is Attorney General Janet Reno, who later
Well, she's the Dade County attorney at that time.
Dade County attorney. So she's the prosecutor. She, just so everyone tracks with this, she ends up being U.S. Attorney General under President Clinton.
Mm-hmm.
So you're being prosecuted by a future Attorney General for
operating a church in a residential zone on that case in Miami Beach. And to do that, they sent prosecutors to Jamaica. I traveled with them and did and recorded all the depositions and stuff, but I lost all that stuff. Some of it's been recovered. There's a website called humanitypleading.com, I think it is, where you'll see a lot of the old recordings I made. And I'm not sure I made all of them, but a substantial number of them.
60 Minutes picks up this story.
60 Minutes picks up the story, and I also went down to Jamaica again when 60 Minutes was there, because we had the church dedication and made a public announcement that the whole world should come and witness. And Dan Rather was blown away by the whole thing and said, whatever you think this is, it's pretty hard to imagine they could fake this. It looks like real religion, so.
And of course, it is real religion.
Yeah, no way it could be fake. That was what he said.
And so the end result of these prosecutions, this 20-ton amount,
And Jamaica recognized cannabis as a sacrament under national law in 2015. So you can see that Jamaica has continued to evolve on this issue to this day.
And then the defenses that you're raising to all these prosecutions in the 70s and into the 80s, including Iowa, there are reported decisions traffic stops where you were involved in where marijuana was seized. But you're raising this defense consistently.
Yeah.
And you brought up peyote, and I think it's important for people to understand the role that peyote plays in this. There is an exception for the Native American Church, an exception from federal drug law and the drug laws in most states that allow peyote to be used by the Native American Church. And as I understand it, what you're trying to do at this time is say what? Comparing marijuana and peyote.
I'm saying there's a religious exemption, and so the government can't say they don't understand the concept of a religious exemption or how to deal with it, and they have to accommodate a request and evaluate that, and don't say, well, we don't accept requests. Because that becomes an establishment of religion. Iowa's got more specific language, privileges and immunities to which others are not entitled on equal terms. It's Article 1, Section 6 of the Iowa Constitution. Article 3 is religious freedom and establishment clause.
And so you're raising this defense saying Native Americans are allowed to possess and consume peyote, and there's this whole system to grow peyote, to distribute peyote.
Mm-hmm.
You want the same thing for marijuana, and it's not being recognized.
Well, the same means similar, I think. In the case of peyote, the Indians kind of got overtaken by the Europeans, and so the ground where the peyote grows is actually owned by somebody other than the Native Americans. So now they're in a position like some private property owner has their sacrament. So the way they work this out, and it only grows in Texas, and I think it grows in Mexico, but then you've got international borders. So it grows in Texas, and the private landowners have agreed to let people come and harvest that, and they're not members of the church. They're called peyoteros. They're licensed by Texas and the DEA to engage in commercial activity with a Schedule I controlled substance on the condition they supply it to this exempt population of people classified as the Native American Church.
And so we've got federal law that exempts Native Americans from prosecution for possession and use of peyote during religious ceremonies.
Mm-hmm. And then federal registration for people supplying and manufacturing the product for them.
So we have this whole framework for peyote.
Yeah.
And
they just applied it to ayahuasca in Arizona a couple days ago in a settlement agreement with the Church of the Eagle and the Condor.
So if we fast forward in time,
and it's the same way as all those things they know how to do it. There's a pattern. There's a
peyote, controlled substance derived from a plant. Ayahuasca, controlled substance derived from a plant.
Mm-hmm.
Marijuana, THC, Delta-9 THC, and all the other cannabinoids.
Involving international borders because it's imported.
So we've got an example of an existing framework. Now you're trying to say that you should have the same exemption for marijuana in these cases.
Well, I'm saying that there should be some kind of a vetting, a consideration of that.
Now, no one ever denied.
I would have to explain how I'm going to do that the same way that the ayahuasca people explain how they're going to do it, and how the peyote people explain how they're going to do it. And the way I would explain it is we have 47 states now that have set up illegal federal racketeering operations to grow and distribute cannabis. We have bulk manufacturers. I thought you were going to go there. We have bulk manufacturers now in several locations that can grow it for federally authorized research, and they could easily supply that for federally authorized religious use. So we're not without these people are already registered with the DEA in the state to grow marijuana. Now, not the federal racketeering ones, but the bulk manufacturers have both state and federal licenses. What's weird is we have one in Iowa that's operating illegally, and they have a federal license for bulk manufacture in Colorado, and it's like the DEA is like overlooking the fact that they're associated with both legal and illegal activity. It's just how loose it is. Like, it's absurd that I couldn't get a religious exemption considering how things have evolved and changed. And now the HHS secretary comes out and says it's not as dangerous as we said it was. It has a low potential for abuse. It's
Right.
it's non-toxic. It's remarkable how safe it is. I mean, so
And
the
we'll
world
get-
is completely turned upside down here.
Hopefully we'll get to the Schedule III bit
Yeah.
toward the end of this. I don't want to jump in. No, it's all right. Because it's there's so much going on. You bring up DEA. You've been involved in a number of actions with the DEA over the years. And when I mean involved, you're petitioning the DEA, suing the DEA, intervening in other DEA matters, looking to reschedule cannabis from Schedule I into something else. You've been reported decisions. I mean, I don't know if there's been anybody else that's been involved.
My name's on the cover of the first federal scheduling decision in 1988, saying marijuana in its natural form is one of the safest therapeutically active substances known to man. My name's on the cover of that administrative law decision, the DEA decision in 1988.
And then if we go a little bit further, did you have federal litigation in the D.C. Circuit, which is a court of appeals, then Judge Ruth Bader Ginsburg, so notorious RBG, she pens an opinion in that. You're involved in that case. Tell me about that.
Well, she said that she agreed with all of the trial courts back in the 80s, before any of this marijuana craziness took off, that the use of peyote was not a burden to the federal government because they were licensed in Texas. They had their supply all figured out. They were exempt. They weren't getting busted for distributing massive amounts of peyote. That was all tight and clean. I didn't have any way of saying, well, I'm going to import marijuana from Jamaica or Colombia where it's not legal there either. And so I had no way of explaining how I could be on the same level with that kind of an arrangement. And so I lost based on the popularity of marijuana and the lack of any kind of a rational argument on my part on how I would control this, how it would be tightly controlled and it wouldn't escape into the wild. And of course, my testimony at that time was that we invited anyone to participate and that it would be totally escaped into the wild, and that was our intent.
And I think it's important to point
in
out
a way, sort of. I mean, a religious context.
When you talk about losing, there's some things that you didn't lose. No one's ever said you're not a member of the church.
Every ruling was that it was a sincere church because that was what Janet Reno uncovered when she sent the prosecutors to Jamaica in 1979. Whether that was a state thing or combined with federal CIA and FBI and every kind of thing, the United States wanted to know what the hell we were doing, and they went and lived with us. Yeah, and professor, the dean of nursing here at the University of Iowa came down and lived with us in Miami and down in Jamaica, and then wrote a story on maternity and the use of cannabis during child birth and child rearing in Jamaica, and so we were really well investigated.
And so in all of these prosecutions, whenever you raise this defense, there are no rulings that say, Carl is not a member of this church. This church doesn't have a sincerely held religious belief about cannabis. Cannabis is not a sacrament.
That's
all accepted.
It was so obvious that we were sincere that what they wanted to do was establish that religion doesn't entitle you to do anything you want to do, rather than saying this is not religious. You can see how it would be important to establish a standard like that, because what if your religion involved human sacrifice or something?
For sure.
I mean, there has to be some way to beat a religious claim without challenging the validity of the religious belief. And it's really hard to challenge the validity of a religious belief. Let's take the pandemic as an example.
I was going to bring that up. So like when it comes to mass, here's a recent example I think that everyone can understand, or vaccines. If I wanted to exempt my children in public school for wearing a mask,
during a pandemic, worldwide
global pandemic, all I had to do was fill out a piece of paper certifying that I had a religious belief. There was no investigation. It was a piece of paper. Yeah. And I did that, so I know how that works.
Yeah. Now, if somebody came and said he's lying, or you made some statement that was clearly a lie and they could prove it was a lie, then they could turn around and say, you're not sincere, you're a fraud. But they don't start out by saying you're insincere and fraud. You get the benefit of the doubt. Like, if you say I have a religious belief, good for you, good citizen.
But that finding's been made by the Iowa Supreme Court with respect to you and the Ethiopian Zion Coptic Church federal courts. You also intervened.
I had them make a finding in each one of those cases that it was a bona fide religion and that I was a sincere member of it, and they did do that. The Iowa Supreme Court did that.
In 1990, you intervened in a U.S. Supreme Court case, Employment Division versus Smith.
No, I didn't intervene in that case. My appeal was pending in the U.S. Supreme Court at the same time. My decision is cited 7 times in the Smith decision, and it's not really cited accurately. It's cited as an example of a First Amendment claim without a equal protection claim, but it was never that. It was a First Amendment claim with an equal protection claim. And Smith said you can't make a First Amendment claim unless the law is not generally applicable or not neutral toward religion. Well, my argument was that the law is not neutral toward religion because of the peyote exemption, and it's not generally applicable because of the same. So my case is mentioned in Smith as if it was a First Amendment claim, which they rejected in Smith, saying you had to have an equal protection claim. They didn't get into the nuance that I had actually got the equal protection claim and lost on that argument.
On the strict scrutiny piece, because the government could come forward with some compelling interest and say that their means were rationally tailored because they wanted to limit who was using marijuana and who it was exposed to. And
so the significance of my name being mentioned 7 times in that decision is just that, hey, I got their attention, that's all. It's not that the case wasn't about me, so the fact that they took me out of context really isn't significant, but it is significant. My name's mentioned 7 times.
There was a point, and maybe it's the late 2000s, maybe 2008.
2008, I tried to bring a case under the Federal Religious Freedom Restoration Act, and the court said the only thing that entitles you to is strict scrutiny, and you got that in all of your cases, so that there's nothing to restore. You never... The compelling interest test was never denied to you, so you can't be restored something you never lost.
And
because Smith did take it away from some people, I just wasn't in that category of people.
And I had skipped over. There were some. There was legislation at the federal level, a Federal Religious Freedom Restoration Act that came about, but.
To overturn the Smith decision.
To overturn the Smith decision.
To say that a bald First Amendment claim alone was sufficient to trigger strict scrutiny. That's what the Religious Freedom Restoration Act did, but only for those cases where it wasn't going to be applied. It didn't apply to me because I'd always got the compelling interest test, so there's no way they could give me back something I didn't lose in the Smith case. But some people lost an argument there. I couldn't tell you who. Well, Smith. Okay, Smith was in Oregon, and they didn't have any exceptions in their drug law, and the U.S. Supreme Court said the First Amendment could not be used as a sledgehammer to force the state of Oregon to accept exceptions unless they already had some. It would have to include an equal protection claim, and Smith didn't have that. And so that's what the Religious Freedom Restoration Act is all about. Much ado about nothing, probably, but anyway.
But Smith didn't have, Oregon didn't have a peyote exception in its state laws or constitution.
Or a medical exemption or anything.
Correct. Now
they got all kinds of, Oregon's like.
But Iowa is, talk about the peyote exemption in Iowa. We've had that legislatively.
Well, the federal government, the state and federal government decided to create these new drug laws, and they wanted to put all these psychoactive plants into a category called hallucinogens. So they decided they were going to add peyote to the federal and state drug law. Well, when the federal government does it, the states do it. Okay, so this was 1965. So in 66, the federal government decides to create a regulation for the exemption for peyote. Iowa adopts that into the Iowa Code in 67, which is, the legislature's annual. So as soon as they could, after it was published in the Federal Register in 1966, Iowa enacts a law and puts it into a statute instead of a regulation. verbatim, word for word. It's not like original language. They didn't write that. The federal government wrote that in a regulation and did not put it in a statute because they felt that would be inappropriate. Should be in a regulation, an exemption.
And so the fact that we've had that peyote exemption in the Iowa Code, that's given you the ability to make this argument.
And the fact that it was copied from federal drug law, but the whole strategy of making it an exception rather than a statute was not adopted by Iowa. And when Iowa adopted its Uniform Act, they wrote a long thing, I can't remember the name of it, but there's a long description of the study that they did before. Andrew Weil was part of this too. They did a big study and they said that they were not going to adopt the administrative functions of regulating. They were going to put it all in a statute. Well, that's fine if you want to remove all the due process, unless a citizen complains that there's no due process. Now it's like, is that true? Well, yeah, it was intentional. It's well documented. They decided not to adopt that. And they thought it was too much of a hassle. Due process, like, what do we owe you? We're the government.
And that peyote exemption enabled you to make these arguments because you could say, hey, you're recognizing a religious use by Native American church. I want this. I want a similar use for a Schedule I controlled substance. That's where marijuana is in our Chapter 124.
Yeah.
But there came a point where you could no longer make that argument. That you were collaterally stopped from making the argument.
Well, we already talked about that. They made a ruling that my use was uncontrolled and that their use was controlled. And then that becomes collateral estoppel. So that takes away your standing to complain about the lack of rules or anything, because you would have to show some possible outcome that would turn out in your favor, and you can't show that the outcome would be any different, so that you don't even have the standing to say, hey, you don't have any due process, because that wouldn't get you anything even if there was due process. Your argument's already been vetted under strict scrutiny in a criminal case.
But what happened between, say, 2008 and 2018 that has enabled you to then raise that argument again?
Well, when I got when I got the ruling in the Smith decision, it pulled the rug out from under me, and I said, I'll never be able to make that. That argument is like gone.
Because your First Amendment argument's gone now.
Well, and the peyote argument.
Yes.
First Amendment with the equal protection. And Smith said you could still raise an equal protection argument with the First Amendment, but I'd done that, so that was out. I didn't have, even though the Supreme Court said you could do that, I'd already done that. So that's collateral estoppel. So I said to myself, well, the federal government is distributing canisters of marijuana to people here in Iowa, 300 cigarettes, and the prescription on the can says smoke 10 a day for a research program. So I hooked up with George and Barbara, the two Iowans on the program, and we started Iowans for Medical Marijuana. I decided to stop using marijuana so that I would be legal. After Smith. And also because of meeting George and Barbara and seeing they were legally using marijuana under state and federal law, I thought, I can't hang around with these people and jeopardize their medicine, because if they get caught hanging around with a criminal, they'll tell them they're disqualified and take them off the program. So we hooked up and started going around and holding events and getting permits for them to smoke cannabis on the steps of the Capitol. And our whole thing was to show that smoking marijuana is not dangerous, it's federally sanctioned, no harm.
Yeah.
So then the federal government decides to cut off that program in 91 or 92 and stop taking applicants. Some guy with multiple sclerosis, Lad Huffman here in Iowa, gets an application in the same time as Barbara. Hers is granted and his is denied. And they both have MS. Okay. So then that becomes a big news story. And then other people started getting arrested for marijuana and doing these things. And the Supreme Court got a case on Bonnier in 2005, and they followed they followed the ruling in the Raich case that it wasn't. I think the Raich, but anyway, they denied the medical necessity defense. So, 96 is when California enacts a medical marijuana law, and it's pretty broad. It's a voter initiative, and it allows people to grow their own and also to form collectives to grow for each other. And so then the Raich case comes along in 2005 and says that's not protected under federal law. And so then in 2010, the state starts setting up these crazy racketeering schemes, businesses to grow and distribute cannabis.
And you know what we might do? Let's take a break here. There's so much more to talk about. I want to make sure that we cover everything. So why don't we take a break here and come back for the next part of the episode in a minute.